The case that concerns us today is Notre Affaire à tous and others versus Total, or more commonly referred to as the Total climate change case. This case has been heard by 4 French courts regarding its admissibility between 2020 and 2024. And thanks to the first complaint, Total Energy is the first company to be sued in a climate lawsuit in France. So in March of 2024, the Paris Court of Appeal inaugurated its new chamber dedicated to emerging litigation, so namely the duty of care arising out of the 2017 Loi de Vigilance and environmental liabilities. And so after years of procedural wrangling, the decision paved the way for a future ruling on the merits of the case. But to go back to the beginning, in June of 2019, 14 French municipalities and several associations sent a formal notice to Total Energy, requesting that the multinational comply with its obligation under the Loi de Vigilance and under Article 1252 of the French Civil Code. Said articles allows for legal action to be taken to stop illegal activities in the event of previously identified ecological damage. In January of 2020, they all filed a complaint against Total Energy before the Nanterre District Court, on the dual basis of the duty of care, which is now in Article L 225-102-4 of the Commercial Code, and on the basis of Article 1252 of the Civil Code. So the aim of the action is to compel the oil company to take the measures necessary to align itself with the objective of the Paris Agreement. So that's to say, to publish a vigilance plan identifying and analyzing the risk associated with its activities, especially those related to climate change. But the applicant also requested that Total be legally required to include measures to mitigate and prevent serious environmental harms, which with quantified targets aligned with the 1.5 degrees global warming limits. All of this was requested through the invocation of the Loi de Vigilance, and additionally, there was the invocation of Article 1252. It was cited to support the demand that Total publish and implement actions to reduce greenhouse gases emission, reinforcing therefore the obligation under the duty of care of the Loi de Vigilance. So for its defense, Total Energy did not respond on the merit and relied on several procedural grounds throughout the different proceedings. So it did so first by questioning that the Nanterre court jurisdiction, requesting that the dispute be brought before a commercial court, which is in France partly composed of company directors and which deals with business-related disputes. So on February 2021, the Nanterre Judicial Court ruled in favor of the applicants. It rejected Total's attempt to bring the dispute before the commercial court, because the judge considered that the associations and municipalities were non-traders, meaning that they had a right of option, which they can exercise freely and at their convenience between the judicial court and the commercial courts. In addition, the court said that judicial courts are considered competent on the ground that the vigilance plan is not a commercial act, but a legally binding unilateral act of civil nature. The order also recalled that the duty of vigilance in this total social responsibility, and that the letter of the Commercial Code provisions relating to the duty of vigilance called for judicial review. So this first decision was a victory of sorts against Total, and it contradicted previous decisions handed down in other proceedings concerning Total's project in Uganda. On the 18th of November 2021, the Versailles Court of Appeal confirmed the decision that the judicial court had jurisdiction, rather than the commercial ones, and it did so relying on the exclusive jurisdiction of certain judicial courts in matter of ecological damage, as stated in the French Code of Judicial Organization. It recalled the desire on the part of the legislator to entrust actions relating to ecological damage only to specially designed judicial courts. And so on February 10, 2022, the case was transferred to the Paris Judicial Court in application of a law of December 2021, which gave exclusive jurisdiction to the court over cases based on the Loi de Vigilance. In September of 2022, the cities of Paris and New York officially joined the coalition of organizations and local authorities that took Total Energy to court. And at the same time, the French city of Poitiers and Amnesty International France also announced their support for the lawsuit.
The case brought before the Paris Judicial Court against Total Energies marks an important and growing step in the application of the French duty of vigilance law. In an order issued on 6 July 2023, the pretrial judge declared the action against the multinational inadmissible. It's a decision that raises serious concerns about the interpretation of the law and about access to environmental justice for associations and local authorities. At the beginning of the proceedings, Total Energies tried to slow down the case by challenging the court's jurisdiction, arguing that it should fall under a commercial court. This strategy failed, and the case was confirmed before the Paris Judicial Court, which is now the only court competent to hear cases based on the duty of vigilance law. In his decision, the judge held that Total Energies had not been properly given formal notice because the claims in the lawsuit were not strictly identical to those contained in the formal notice sent to the company in June 2019. Such a requirement of strict identity appears nowhere in the law. By creating this additional condition, the judge artificially restricts the ability to bring a claim under the duty of vigilance framework. The judge also reproached the association for a lack of prior dialogue with the company. However, the law imposes no obligation to engage in a phase of consultation or conciliation before going to court. In reality, the coalition of associations and local authorities had contacted, exchanged with, and even met Total Energies executives before sending the formal notice. The steps were not acknowledged by the judge, who considered that simple meetings could not constitute a formal warning. This position seems even more questionable given that Total Energies never showed any real willingness to engage in dialogue or take concrete action to address the concerns raised. The judge also found that several associations and local authorities were inadmissible, ruling that they lacked standing to act under the framework of ecological damage. Such an interpretation appears to contradict the jurisprudence of the French Conseil d'État, particularly the Grand Sainte decision of 10 May 2023, which explicitly recognizes the right of associations and local authorities to act in order to prevent serious environmental harm. The law itself provides that any person with an interest or capacity to act may bring a claim to prevent ecological damage. The judge further considered that the municipalities involved lacked standing because the effects of climate change are global and not limited to their territories. This reasoning ignores the fact that many local authorities, especially coastal ones, are directly affected by the impact of climate change. According to the judge, allowing such actions would make climate litigation impossible to control. This argument is hard to understand, since this is the only case brought before a judicial court by municipalities directly exposed to this effect. This decision is part of a broader trend. In recent months, several other cases based on the duty of vigilance law have also been declared inadmissible, such as Telenga and EACOP in February, Suez versus Chile in June, and EDF versus Mexico in December. We are therefore witnessing a worrying narrowing of access to justice, even though the duty of vigilance law was precisely designed to hold major companies accountable for their human rights and environmental impacts. By refusing to examine the substance of the case, The court deprived society of an essential judicial debate on Total Energy's contribution to climate change, sending a contradictory message at a time when the environmental emergency has never been more pressing.
And finally, let's talk about the appellate decision and what's next. On the 18th of June 2024, the Paris Court of Appeal overturned the previous decision of the Paris Judicial Court, which had declared the NGO's action inadmissible. So the court declared the action receivable, allowing the case to finally be heard on the merits. Now, it's important because it clarified a few points. First, it relaxed the interpretation of the required formal notice, called mise en demeure, which means that it doesn't have to be strictly identical to the later claim. Second, it acknowledged the standing, the locus standi, of NGOs in certain local authorities, and here in our case, the city of Paris. And third, it allowed a combination of legal grounds, which means that the duty of vigilance under the 2017 law and Article 1252 of the Civil Code, which is about the environmental damage, can both be used together. Therefore, what's the meaning of this? The court did not yet rule on whether Total Energy breached its duty of vigilance. It simply confirmed that such claims can be heard by a judge, which is a decisive procedural victory. Now, why is it a historic decision? Well, on a legal standpoint, it's the first time a French appellate court confirms that the duty of vigilance can be judicially reviewed. It means that the court adopted a less, let's say, formalistic interpretation of the 2017 law, contrary to the first instance judges. It also confirmed that civil society actors have a legitimate role in enforcing corporate accountability. French courts are now ready to analyze and judge the climate strategies of corporations, even those of powerful corporations such as Total Energy. On a more symbolic standpoint, it kind of gives a new momentum to climate litigation in France and even in Europe. It aligns with international trends, such as the Shell case of 2021 in the Netherlands. Also, it supports the Future Corporate Sustainability Due Diligence Directive, the CSDDD, a European directive that is actually in the works to hold accountable companies for their climate commitments. And it is especially important that on the 19th of June 2024, the Paris Court of Appeal delivered actually 3 rulings. The one of Total Energy, which was considered admissible, as we've seen. The one of EDF, which was also considered admissible. And the one of Suez, which was not considered admissible because the link between vigilance and climate was judged too weak. Therefore, it shows the willingness to break down procedural barriers in order to tackle climate litigations. Now, the questions are, how far can judges go in ordering a company to modify its vigilance plan? Can courts require concrete measures, or will they assess compliance in general terms? What is sure is that while the Court of Appeal's decision does not yet resolve the climate dispute, it opens the legal path for the first time to a genuine judicial review of corporate climate responsibility, which will perhaps inspire other lawsuits against major corporations. Thank you for listening to us, and we hope you learned something and find this presentation interesting.